Inventors, listen up. Your groundbreaking idea could be worth millions, but only if you protect it properly. Today, we're diving into the world of patents, your legal shield against idea theft, and your ticket to turning innovation into profit. So what exactly is a patent? It's a government-granted property right that gives you exclusive control over your invention for a limited time, usually 20 years. This means you can stop others from making, using, or selling your creation without your permission. Now let's walk through the key steps to securing your very own patent. First, you need to ensure your invention is patent eligible. The United States Patent and Trademark Office, or USPTO, has three main criteria. Your invention must be novel, useful, and non-obvious. In other words, it needs to be new, have a practical purpose, and not be an obvious improvement to someone skilled in your field. There are four main types of patents: utility patents for functional inventions, design patents for unique aesthetic features, plant patents for new plant varieties, and software patents for, well, software. The type you need depends on what you've created. Before you get too excited and rush to file, it's crucial to conduct a thorough patent search. This step helps you determine if someone else has already patented your idea. Start with the USPTO patent database and expand your search to scientific journals and global patent databases. If this sounds daunting, consider hiring a professional patent researcher. Once you're confident your invention is unique, it's time to prepare your patent application. This is where things get technical. Your application must include an abstract background information, a summary of your invention, a detailed description, and a conclusion highlighting its key advantages. You'll also need to provide detailed sketches or drawings. If you're not quite ready for a full patent application, you can file a provisional patent application. This gives you a year to further develop your invention while marking it as patent pending. Now, here's a word of caution. The patent process is complex, and mistakes can be costly. Common pitfalls include insufficient prior art searches, inadequate descriptions, and missing crucial deadlines. That's why many inventors choose to work with a patent attorney. While it's possible to file on your own, professional legal guidance can significantly increase your chances of success. After filing, your application will be assigned to a USPTO examiner for review. This process can take 1 to 3 years and may involve responding to questions or objections from the examiner. If approved, congratulations, you now have a patent. If denied, you have the option to appeal the decision. Obtaining a patent isn't just about protecting your idea, it's about maximizing its potential. With a patent, you can license your invention, sell it to interested parties, or use it as leverage in business negotiations. It's your hard-earned competitive advantage in the marketplace. Remember, patents are the lifeblood of innovation. They encourage inventors like you to keep pushing boundaries, knowing your intellectual property is protected. So if you've got a game-changing idea, don't let it slip away. Take the steps to patent it and turn your invention into a valuable asset.